Thank you so much, Masi, my friend. Midday is a good time to start. I'll quickly go to introduction of the panelists, beginning with Paul Ngotho, who is on the screen there. Paul is a full-time arbitration practitioner. He's an author and a tutor with a master's from in the degree International Dispute Resolution, University of London. He's on numerous arbitration panels in Africa, China, the UK, as well as the USA, and has arbitrated a wide range of disputes, including property, sales, construction, and infrastructure. Paul is a chartered arbitrator, and his experience as a sole arbitrator. He also acts as an umpire and chairman, and recently chaired an arbitral tribunal, which determined a 2.5 billion succession dispute, which was in the courts for 27 years. So already the benefits of arbitration can be seen there. He's also an author of arbitration articles, and he's disserting in the PhD, and he's also a valuer, and that's his profession. Next, please. We have Diana Sawe, who will also be joining us online. Diana is a corporate secretary and chief manager legal affairs at IRA. She's also the chair lady of the Institute of Certified Secretaries. Diana is a fellow of the Chartered Institute of Arbitration and an advocate of the High Court with over 25 years experience. She has interests in corporate governance, ADR, regulatory affairs and compliance, and is currently a member of the CASNEP board and previously served as a member of the Council of Legal Education. Diana is also a member of the Institute of Directors and the Women on Boards Network. She also serves in various capacities in her professional and career, and is a mentor with the Young Women on Boards Network. Finally, but not least, is Pierre Durou. He's a lawyer and a counsel at Transitional Arbitration and Litigation. Yes, my French is that bad, but I guess he'll interpret that. He's joined us from Paris. He's one of our in-person guests today from outside Kenya. That's a Paris-based independent boutique law firm specializing in complex, sophisticated, and often politically sensitive and transitional investment and commercial disputes involving sovereign states, state entities, and state-owned corporations. Pierre has experience in the oil, gas, mining, and construction. He's also an independent arbitrator with a wealth of experience in arbitration, which has gained in the last 10 years through his participation in over 50 arbitrations, and as an arbitrator, party representative, and administrative secretary of the sought-after full-time arbitrator. So welcome, panelists. This panel's discussion, I hope, is very relevant, especially to the SME sector, for two reasons. The SME sector is both the backbone of our economy by virtue of being the largest employer. Naturally, the SME sector is where you find most disputes, especially commercial disputes. So we hope that this panel discussion will shed a lot of light on what ICC and even arbitration in general can do for the SME sector. We shall begin our panel discussion with a PowerPoint presentation by Pierre, and then we shall delve into the Q&A. Welcome, Pierre.
Thank you, Kenneth. And thank you all for joining us today, either in the room or from a distance. And thank you to ICC Kenya and the ICC in Paris for this event, which I believe and I suspect is going to be just the first of a long series of events here in Nairobi or in Kenya. So as Kenneth just mentioned, SMEs, or actually MSMEs, as I've discovered yesterday, Kenyan says, the M being the micro, prior to small businesses, is the vibrant heart of any economy, the most source for employment in any economy. Those companies are tricky companies for any dispute resolution mechanism to deal for. This is because they have, or they're believed to have, limited resources, a limited scope to accept delays in resolving disputes, because a delay in resolving disputes may delay the development of a technology, may delay the development of a firm, because the cost engaged in litigation or in resolving a dispute will not be used to hire another employee, to develop another project. And over the years, the overall legal community and economical community have targeted SMEs and their access to litigation and their access to alternative dispute resolution to help those companies, to support those companies. And the ICC answer to all those discussions about how can SMEs access better to litigation and dispute resolution was the introduction in 2017 of the expedited procedure provisions. So I will be, and in interest of time, I will not be going through all the slides because it may bring us actually way before, after, and longer than the overall time we've been allocated. But some very brief presentation and comments on EPP as we call it for the benefits of the SMEs. So EPP basically is a combination of the application of Article 30 of the ICC arbitration rules and Appendix 6 of the same rules. The EPP applies, and I think that Danga mentioned that over the morning, applies depending on a threshold, the value of the amount at stake. So at the time in March 2017, when the EPP was introduced within the rules, the threshold was $2 million. So for disputes below that amount and for arbitration agreements that were concluded after 1st March 2017, you could access to the EPP. Since earlier this year, January 2021, the threshold has been increased to $3 million. And I will go back to that because this is a sign from the ICC that EPP actually works and that the users are really using the provisions. And there is, as in every arbitration proceedings, there is flexibility. Flexibility in the sense that even if your arbitration agreement was concluded prior to March 2017, or that the amount at stake is above the threshold, the $3 million or $2 million threshold, you can still, the parties may still decide to opt in if they believe that following an expedited procedure will assist in the resolution of the dispute. And flexibility works the other way around. It's possible for the parties to opt out from the EPP. So if your arbitration agreement was concluded after March 2017 and you're below the thresholds, normally it's automatic application of the EPP, but the parties may still decide that they don't want to go for the quickest path and they want a full-scale arbitration. This is possible. And the court as well, the ICC Court of Arbitration, has the authority under the rules to decide that the EPP will not apply for various reasons of circumstances and upon application by one of the parties. So that's Article 30. And for Appendix 6, which is basically the equivalent of the overall arbitration rules, but that is targeting EPP, tells you that it is a simplified procedure, so a simplified arbitration, which allows for the arbitration to go faster. And it's also a cheaper arbitration. I've listed in that slide the various provision of the expedited procedure, Article 2, which irrespective of the arbitration agreement, the court may decide to appoint a sole arbitrator. You only have one arbitrator. It's ease the process, reduces the fees, and it's appointed by the court if the parties are not able to allow. So it streamlines the process of constituting the arbitral tribunal, because be it in commercial arbitration or administrative arbitration, being an arbitral tribunal takes time and is a very tricky process. Danga mentioned over the morning the challenge, a recurrent challenge by parties over the arbitrators appointed by the other party. It can. I've recently received an appointment of the president presiding of an arbitral tribunal in a proceeding in which the request for arbitration was filed late in 2017. So we are almost 4 years just to constitute arbitral tribunal. Well, through the IPP, you more or less guarantee then 2 months, 2 months and a half after, at the latest, after filing the request for arbitration, you have an arbitral tribunal in place. Article 3.1 of Appendix 6 tells you that there is no terms of reference. Terms of reference within the arbitration rules basically frame the scope of the dispute, tells you a bit about the seat, the language. They take time also to establish. There's a timeline and a deadline for the arbitral tribunal to remit the signed copy of the terms of reference. But this you don't need in IPP. You just move forward with the resolution of the dispute. It doesn't mean that there is no procedural rules applicable, because the arbitral tribunal must likely, after consulting the parties, will set the rules that he or she or them, if there is more than one, considers appropriate to follow. So it's not something that you lose by not having the terms of reference. You actually gain time while you still have the ground rules of the proceeding that are going to be established by the arbitral tribunal. The other improvement is the case management conference, which is an ICC specificity. Well, it was, and other institutions now have now copied the ICC, and that's the way it works. Case management conference was referred to by the President Claudia Solomon this morning. Is very important, because that is most of the time the first direct interaction between the tribunal, the arbitrators, and the parties, in-house counsel, potentially external counsels, that will set the tone of what this arbitration really is about, what the parties are expecting, whether they want to go quick, whether they want to go slow, expert evidence, witness statement. It's the first really interaction so that you can decide what this arbitration will look like. This case management conference has to take place within 15 days, a couple of weeks after the arbitral tribunal has received the file of the arbitration. This has two impacts. The first one is that it speeds the process. We're only talking about 14, 15 days. The second one is that the arbitrator or the arbitrators needs to really dig into the details of the case quickly. Because in my view, and I've experienced that as an arbitrator, you cannot really take everything that a case management conference can help you get without knowing already at that time what the case is about, without having already considered the party's position and any correspondence that was sent to you by the Secretariat. So within 15 days, the parties can more or less guarantee that traders already know what the case is about and have already read the case file. After that, basically it's a matter of negotiation. The next timeline is 6 months after the case management. The award needs the award, the final decision, 6 months after the case management conference. So overall, this means that an EPP, expedited procedure arbitration, is going to be resolved within less than a year. Within less than a year, you have an award that is enforceable under the New York Convention that you can easily circulate if your counterparty was an international and cross-border partners, less than a year. This is the answer by the ICC to SME's concern for the lengthy arbitration, lengthy litigation. And the other aspect, which is not procedural, but is nonetheless very important for the parties, is Article 4.2, which is a 20% reduction as per the scales of the tribunal fees. So most of the time you have only one arbitrator, and because the proceeding goes fast, fees are going to be reduced by 20%. And because, and this is not the rule, it is an impact and a consequence of the EPP nature, because the procedure goes fast, we are more likely to pay less as well, because they will have less time to prepare lengthy submissions, to charge you for that, because the path is quite straightforward. So there is little room in mind for guerrilla tactic and filing submissions after submissions, applications after application, because basically the arbitral tribunal knows that they have a sword against their head, which is the 6 months period to deliver their award. So they will be more hands-on with deadlines, more hands-on with the case, and they will not accept that the arbitration derail. Very few numbers in 2 minutes maximum for the EPP in practice. After 3 years plus of experience at the ICC, the Secretariat shared some 2017-2020 statistics on the EPP. So 247 EPP cases have been administered so far over 3 years, which show it's a success, because here you have to remember that the starting point was 2017 for the introduction within the rules. But the criteria there was for the arbitration agreement to be concluded after 1st March 2017. So normally it takes more than 3 years for arbitration agreements to be concluded and to come to dispute. But here it shows that users are using EPP very quickly and are actually quite satisfied with that. I mentioned the opt-in, opt-out, so the parties have understood the way it works. As in 77 cases, parties have accepted to opt in even though they did not meet the criteria. There was 166 automatic application of EPP, so all the thresholds and the legal requirement for the timing of conclusion of the arbitration agreement was met. The court also has already developed its practice with 38 decisions at the end of 2020. I will not go into the details of those decisions in the interest of time. And so far, over 100 awards, final awards, were rendered in EPP cases. The concerns of SME and lawyers mainly, I guess, for the EPP was that maybe that would lead to some kind of breach of due process or less quality in the award, because speeding things up, then basically you reduce what you can do because you have no document production phase, you have no witness statement, you have no expert evidence. Well, practice showed that it is not the case. It's just a matter of reducing the time frame, but a document production phase take place even in EPP. So you can still encompass the possibility of obtaining crucial document from the other party, even if it reduces the time. You have a majority of cases, 57 cases in which hearing take place. Whereas it's possible to have a documents-only procedure under the EPP rules, but the majority of the parties in the cases, a hearing took place. So the parties were heard and potential witness were heard as well. And even after the hearing, post-hearing briefs, which most of the time, you really question yourself as a lawyer whether it's really necessary to engage into a further submissions. Generally, when you have lengthy hearings with witness and expert evidence, yes, it may make sense to emphasize on the true results of the hearing. But when you have a one-day hearing in an EPP case, short submissions, well, you could wonder whether this is really necessary. But the parties have used, and the arbitral tribunals have allowed past hearing briefs to be filed within EPP cases. So basically, you've heard a lot, and we've practiced a lot in arbitration. We're used to spending several years on cases, but since 2017, and thanks to the ICC, this is changing. I've experienced EPP both as a counsel and as an arbitrator, and I can tell you that it works. It works especially for SMEs because it meets the needs in terms of finance and velocity of the SMEs, but it works also more globally. But it requires one thing. It's a word that we've heard a lot this morning, which is expertise. It requires expertise from the arbitrators, because you can get lost in what you can do, and you can be tempted not to allow the parties to do anything, which is not the purpose of EPP. And in my view, it also requires a lot of expertise and specialization on the lawyers that you're going to use, because we've seen a lot of commercial lawyers doing arbitration, because in the end, arbitration is only a procedure. Once you know the tricks, once you know the tools, you can use it as a lawyer. It's a legal tool. But for the EPP, that specialization of the lawyers that you're going to require is, in my view, even more acute, because going fast may represent a risk, and those risks are best mitigated if the counsels you instruct have already experienced at the ICC. Thank you.
Okay, thank you so much, Pierre, for that presentation. I'm sure it connects a lot with the local business community. The expedited procedure, you've heard about all the benefits, briefly being shorter turnaround time, reduced costs, of course, simplified procedures. That I'm sure will add value to the morning discussion on the benefits of arbitration over litigation. We shall continue in that spirit by bringing in Diana Sawe, who is joining us online. Could we, good morning, Diana. Oh, no, it's afternoon. Good afternoon, Diana. Can you hear us? Are you with us? How about Paul? Paul Ngozo, are you with us?
Yes. Yes.
Thank you, Paul. As we wait for Anna also to join us, we could expand on this theme of arbitration for SMEs by talking about are there expedited arbitration procedures available in Kenya? And how does it work, Paul? Maybe you could share with us today.
Good, thank you very much. Thank you very much. The short answer is yes. There are expedited procedures available locally in Kenya, and they have been available for many years. This is not new. For example, the Chartered Institute of Arbitrators Kenya Branch Arbitration Rules of 2012 have Rule 16, which is about simplified procedure. Then the later rules, or the current or the latest rules from CIAB Kenya are of 2020. And they have two interesting innovations, which I must say were benchmarked from other arbitral institutions. One is document-only arbitration under Rules 74 to 76. And this provides for the claim, defense, and other documents which the tribunal directs or requires, and then substantive oral hearing only in exceptional circumstances. Now, the 2020 rules also have the fast track procedure provided for in rule from 77 to 87. And in brief, this is what they provide for. Fast track procedure is recommended for disputes which do not exceed 10 million Kenya shillings. That is about 77,000 euros at the current exchange rate of 130. Parties must, of course, agree expressly to the fast track procedure. The arbitration is conducted by a sole arbitrator, and the arbitrator is appointed from a special pool of arbitrators pre-qualified specifically for the fast track arbitrations. Now, the tribunal must convene the preliminary meeting within 7 days of appointment. And then the written statements, including witness statements, must be completed within 21 days. That is statement of claim, 7 days, defense and counterclaim, another 7 days, reply to the claim and defense to the counterclaim within another 7 days. That's a total of 21 days. So we are at a month. A month from appointment, the tribunal must have received the last written statement and witness statement. And then the tribunal has 1 month to issue the award. Remember that an oral hearing is not contemplated except in very, very exceptional circumstances. Now, that one period of 1 month for the tribunal to issue an award can be extended by the tribunal, but by only 7 days. The tribunal and the parties are not allowed to extend that period for the tribunal to give an award. So it's not a matter of party autonomy. This is very tight, a very tight deadline. So in other words, an award can be given within about 2 months of the tribunal's appointment. I would like to make some remarks about the expedited procedures. Simplified and expedited procedures have been quite unpopular in Kenya, even when parties' attention is drawn to those procedures. The parties still opt for full procedures, unfortunately. The other comment is that parties which make expensive choices in terms of procedure should then not be heard to complain about delays and costs. Arbitration is about power to the parties. The parties are very powerful in terms of the choices they make. When they make frivolous challenges to the arbitrator for alleged bias, for jurisdiction, for this and the other, or they don't pay the tribunal in time to facilitate expedition, then they cannot turn around and complain about delays. Now, the other remark is that expedited procedures are hugely successful internationally in construction adjudication and dispute boards. I don't need to give examples because I don't have time. I wish I had. Now, the other comment is that never underestimate the human need of being heard, physically being heard by the tribunal with ears, not through documents. This is a very deep human need. People want to see the arbitrator, even if it's virtually. They want to to check if he is listening. They want that assurance. They want that physical contact as an assurance. Now, the final remark on these expedited procedures is that, unfortunately, they might suffer the same fate as the emergency arbitration, which, in spite of all the benefits it offers, has not proved as popular as it deserves. I think I've answered your question. Thank you.
Thank you so much, Paul. I think you've brought out clearly and explained in detail the benefits available. I'm sure the business community and all of us in this today will appreciate that. And you've also come out clearly of the need to balance the basic tenets of arbitration, notwithstanding the urgency to conclude the matter expeditiously. I think that comes out very clearly because as a profession, we have to stick to some basic tenets. I want to bring an interesting concept, Paul, before we wind up. Very interesting in terms of what we call self-representation. This would be relevant to the SME sector because from the first panel, there are challenges with costs and any party to arbitration would like to reduce their costs to a minimum.
Thank you very much. Now, self-representation is when a party appears in person or through its own directors, partners, officials, or employees, including in-house counsel. Self-representation has got very many benefits. It gives a party better control of the process because, for example, the party will not need or will not wait for briefing from external advocates or representatives. It also saves money. And even in terms of preparation, there is less preparation time because each party has most of the documents it will require in the arbitration, as opposed to an external representative who needs time to receive those documents from the party and also to understand them, seek clarifications, and seek more documents and all that. Kenya's State Law Office has done a commendable job in representing Kenya in arbitration internationally. And I must add that the State Law Office of Kenya has won, as far as I know, every international arbitration for many years, including the Kenyan arbitrations from the 70s. It's just like the marathons, my friend. We keep winning and winning. But let me point out some disadvantages of self-representation. It denies the party the benefit of external or independent advice. We all have blind corners, and we tend to like hearing our own voices. You have seen it in various types of disputes where people keep repeating the same thing to themselves, even when it's completely irrelevant. It happens all the time. And it helps to have an external advisor to tell a party, no, this is not making sense, this does not add up, can we put it differently or exclude this altogether? That benefit is missing in the case of self-representation. Also, SMEs lack specialist knowledge, especially in dispute resolution. Dispute resolution is a very specialized field, and we find it in arbitration all the time. You know, top lawyers, senior counsel, people who are top litigators, when they come to arbitration, even though those people know the civil procedure back and forth, when it comes to arbitration, they are completely lost. And so what I'm saying is that dispute resolution is a specialist field, and there are many opportunities for SMEs to get that through outsourcing. The other thing is that self-representation diverts resources from productive activities. Every business has a strategy, whether that strategy is in writing or not, and it engages or acquires resources specifically for the achievement of those strategies. Now, when you bring in out of the blue litigation or arbitration and require your MD, your legal department to divert and deal with this, then that can be quite diversionary. In closing, I'll do a summary. Self-representation has advantages and disadvantages, which every party must consider when making the choice of whether to represent itself or to get external help. The second remark is that, needless to say, representation, whether external or internal, does not have to be by lawyers or advocates. Nearly all arbitration rules and laws allow non-lawyer representation in arbitration. The choice should be made based on the nature of the dispute. Allow me to close this with a quote from Abraham Lincoln. And it's that a man who has his, sorry, I beg your pardon. A man who is his own lawyer has a fool for a client. That is Abraham Lincoln. Thank you very much.
Thank you, Paul, for your words of knowledge and wisdom and a bit of humor on that. You've touched, as we speak, on the expedited procedures and the benefits of arbitration. You've brought out the concept that much as self-arbitration is available as an alternative, especially for the SME sector and the MS sector, there are pitfalls and there's knowledge that is required. And that brings us to the concept of the importance of an arbitration clause, especially for the medium and the small and medium enterprises. I don't know if Diana is with us. Is Diana on online?
Good afternoon, Kenneth. Yes, I am here.
Excellent to hear you, Diana. So we have delved into the benefits, and now we are coming to a concept that is going to tie with what Paul has shared with us. The importance of an arbitration clause in contracts. And this is very relevant, especially to the small and medium enterprises. Thank you, Diana.
Right. Good afternoon, ladies and gentlemen. So it's a pleasure to be here this afternoon just to share some insights on this important discussion on arbitration in respect to SMEs. And what I want to highlight, following what Kenneth said in your opening remarks, is SMEs are very important because of the role they play in the sector, especially in Kenya. And we know that they provide employment generally to majority of the Kenyans. And we know it also contributes to a very high percentage of our GDP. And we know that the challenge they face, amongst others, is the issue about how to access effective and cost-efficient and time-saving dispute resolution mechanisms. And therefore, we are saying it is very important that SMEs really, in a very deliberate manner, consider alternative resolution of disputes so that this can really save the time to enable them focus on the strategy of the business. And therefore, they are able to do this by ensuring that in all the agreements they enter into, there must be an arbitration clause. And it is important to note that an arbitration clause can be incorporated as a term of a contract, which is a general contract giving terms and conditions for any other engagement between the SME and the party. Or when an issue or a dispute arises, the parties at that point can enter into an arbitration agreement specifically to resolve the issue in question through arbitration. And in this case, it is very important to ensure that when this clause is drawn, then it highlights the various aspects of the arbitration as to how the parties are going to engage and how the arbitration will be addressed. And therefore, because arbitration is an issue that parties must agree from the beginning, it can only come alive once parties have agreed that our issues will be resolved through arbitration. So therefore, the first point, as indicated, to ensure that the contracts have an arbitration clause when they sign contracts with their counterparties, with their business partners. In the event that such an agreement does not have an arbitration clause, the option is to still resort to arbitration by filing a submission agreement, which is also referred to as an arbitration agreement, where they should be able to go into the details to indicate their acceptance to use arbitration as a way of resolving that dispute, and to go further and enumerate how the arbitrator can be selected and how the arbitration will be run, all the way to aspects of probably who will bear the cost of arbitration. And I think just to, not to belabor the point, but I think it's very important to note that arbitration is very beneficial for SMEs, just to ensure that they manage especially stakeholder relationships, because we know they are a very important pillar of the economy. Then stakeholder management is very important, because then these relationships are also a capital to these SMEs. And therefore, in managing disputes, in using arbitration, because of the issues of confidentiality, the issue of moving very fast and resolving the issue without raising any fracas or affecting the reputation of the business, then therefore the SME is able to meet its objectives while ensuring that the business continues to run. Thank you, Kenneth. That's what I can say for now.
In closing, there's the aspect where the contracts have been signed, and now we are at the end of the arbitration, which is the award. In arbitration, we call it the award. Now, we would like to know whether the award is binding on companies, and what are the limits of appealing an award under the Kenyan law. Diana?
So thank you very much, Kenneth. For purposes of arbitration, it is noted that arbitration awards are final. Arbitration awards are binding. Binding because the parties from the onset decided to go through arbitration, and the process went through to its conclusion. And it is binding because the arbitrator has looked at all the factors affecting the case and has made a final decision on the matter. However, in an instance where a party feels that they are not happy with the outcome of the award, there are two options provided under the Arbitration Act, as initially indicated. So the first scenario is where the party decides to appeal to the High Court, but this is on two strict conditions. Number one, both parties must agree that the other party who is aggrieved can appeal. And the second point is that the appeal can only be on points of law, but not on the issues of the facts of the case or any other aspects of the procedure, because it is thought that the procedure was already agreed between the parties. We have also the option of setting aside, which is where the law under Section 35 allows that a party can apply to the High Court to set aside, but the law is very quick to also highlight and specify the grounds upon which such an award can be set aside, some of which include, for example, a party did not have capacity to enter into that agreement. The other one may include the aspect of maybe there was fraud, there was corruption in procuring the award. The other one may include aspects like it is not valid within the law upon which the arbitration was conducted. That award is not valid, is not holding within the law. And the last one, just to mention but a few in the interest of time, is the fact that, for example, public policy has been affected or will be negatively impacted by such a decision. So Kenneth, in summary, we are saying these decisions are final, they are binding, but there are exceptions where a party can set aside and where the appeal can be done, but in accordance with the strictures of the law. Thank you very much.
Thank you so much, for sharing the information with us. At this stage, we go to Q&A. We could have questions fielded, and the panelists can then answer the questions that are there. The questions. How is EPP relevant in the Kenyan context? I think, Paul, you can share an answer on how EPP is relevant in the Kenyan context. Looks like Paul is not with us. Okay.
Yes. Please clarify what you mean by that abbreviation.
The question was, how is EPP relevant, I believe, to the Kenyan context? Briefly.
EPP meaning?
Expedited Procedure Process.
Okay, good, thank you. The relevance of expedited procedures. I wish the participants in arbitration in Kenya would embrace expedited procedures. But somehow they end up choosing the full procedures. And then they end up complaining about time and costs. An arbitration in Kenya can be completed within a matter of 6 months with everybody cooperating. But we have arbitrations running for a year and longer. We also have situations where arbitrators have completed their awards, but the parties have not paid the fees. And so the arbitrators have been sitting on awards for months, even years. You know, all I'm saying is that if the parties embraced expedited procedures, then we would save time and money for everybody, including for tribunals. You know, when you take on an arbitration, as an arbitrator, you look at your diary the next couple of months, and you look at it and say, yeah, I can take on this matter. If the arbitration drags on for 2 or 3 years, you might have other engagements which slow down your writing of the award, or even availability to write the award. So arbitration should be expedited, but because arbitration is party-driven, it is up to the parties to make the right choices. Expedited procedures, just like arbitration, cannot be forced on the parties. Parties must choose expedited procedures themselves. Thank you.
You can. I think that EPP, broadly speaking, is a relevant Kenyan way or outside of Kenya. But for Kenya and for some part of the world, I believe as well that for SMEs, what we should always consider is, I believe, the importance for the people managing companies of that size to maintain stability in the value. The outsiders, the potential investors, see them as an investment opportunities, and offering to those potential investors stability, predictability in terms of timing of dispute resolution allows to maintain some competitiveness in the market for the company, but as well to maintain some value as an investment opportunity. So I think it goes way beyond just the funds that are needed to go to litigation or arbitration, but also as to what the business looks like and what can the business do in the future.
Prefect Mercy, have any other questions from, I believe we've covered on EPP, perhaps the next question. Good question. Why would one want to prefer ICC rules, the Charter of Arbitration, Kenya rules? Any panelists, Paul or Diana, if you could take on that briefly. The preference of one set of rules over the other.
Thank you, Kenneth. Because we have agreed that Arbitration is really a matter of choice, and it is upon the parties to select the procedure, the law within which the arbitration will be conducted. I think this will really depend on the material aspects of the contract and the business context of the parties to the contract. Because if, for example, there are aspects of the ICC rules which are beneficial or which will work to the advantage of the parties, then definitely that would be preferable. And also, depending on the location of the parties and their preferred mode of having the issue, the dispute resolved, then some of the advantages would come from having a look at the contract, at the aspects of the dispute being considered, and the business context of the parties. That is what I would say, so that if the rules are really beneficial to the parties in that context, then that is the rule that they should apply for purposes of the procedure of the arbitration. Thank you, Kenneth.
Thank you so much for that. I believe we are at the end of Pierre, you have something to close?
Yes, just one on that. I believe it was a remark that was made during the first panel. Within the ICC context, the award is scrutinized before it goes. And it is especially relevant for EPP proceedings where parties may be concerned that due to the speed of the proceedings, some mistakes may be made, or the quality of the compliance of the decision with respect to the rules. And I think that this is something that plays in favor of the ICC over the chartered rules, because it grants the parties with a bit more security as to what the final product of the resolution process will be.
Thank you so much. Pierre's presentation will be available for those who would like. You can contact the ICC Kenya Secretariat. Details on the EPP procedure. With that, I think we can hand over to Mercy. I'm sure she has a more interesting agenda waiting for us. Mercy.